Hi everyone, this is Pennsylvania attorney Evan Gutman presenting you with video number 11 in my legal education series of the good moral character requirement in order to obtain a license to practice law. This legal education series is based upon my book, State Bar Admissions and the Bootlegger's Son. The full book, along with a supplement I wrote a few years later, is currently available on my websites, two of my websites. I have two websites, heavensadmissions.com and gutmanvaluations.com. Those websites also contain a third book, which is a fictional novel I wrote titled Heaven's Admissions Process. The fictional novel compares the criteria to be admitted into heaven, which is a humorous, somewhat comical, light fictional novel, with the criteria to become an attorney as regards to good moral character requirement on earth. So here we go with video number 11. Today I'm going to examine what is known as the inverse relationship between unauthorized practice of law requirements, between unauthorized practice of law, they're not requirements actually, they're against the law, between unauthorized practice of law and State Bar Admissions good moral character standard to obtain a law license. So UPL, the unauthorized practice of law, is against the law. You're not allowed to do it. The problem is the courts have really wrestled with exactly what constitutes the practice of law. It's very difficult, ambiguous, and vague to determine. When does giving legal advice, utilizing your free speech rights, constitute actually stepping beyond your free speech rights and constitute engaging in the unauthorized practice of law? For instance, imagine your spouse, your son, your daughter, close relative or close friend has just been arrested for a crime they did not commit. You go to visit them in jail. You ask them whether they committed the crime, and they say no, and you believe them. You then tell them when they appear in front of the judge, enter a plea of not guilty. Is that legal advice? When you say to them, enter a plea of not guilty for a crime you didn't commit, is that legal advice? As you exit the county jail in which they are being held, a state official comes up to you, hands you court documents and says, because you told your relative, son, daughter, spouse, or friend to plead not guilty, you need to appear before a judge to defend yourself against the charge of engaging in the unauthorized practice of law. Does that sound far-fetched? Probably so. It probably does sound far-fetched. But it's not quite as much as you think, because UPL is any time you provide legal advice. But the problem with UPL, unauthorized practice of law, is that it is always enforced on a selective basis. Realistically, what occurs, it's only enforced against those who present an economic threat to the legal profession. So in the example I just gave you, chances are you would not be charged for engaging in UPL. However, let's change that hypothetical just a little bit. Let's not change the hypothetical. Instead of just telling your friend, relative, or close friend to not plead guilty, you sit in the courtroom where they're being arraigned. And when the judge asks the defendant what their plea is, your friend, relative, or spouse says, is this when I say not guilty? And you say, yes. Now you're in open court. Your chances of being charged with UPL have increased a bit, but you probably still wouldn't be charged. But now let's change the hypothetical a third time. Your friend, family member, or relative has called you because they know you are an attorney. You're an attorney. But the problem is you're not an attorney in the state where they live. You're an attorney in a neighboring state. Same fact scenario. You're in the courtroom. And now they ask you, and the judge becomes aware that you're an attorney. now you represent an economic threat to the legal profession, and you could actually be charged with UPL, sitting in a courtroom, telling your friend, spouse, family member to plead not guilty. You provide the exact same legal advice, but now you're an attorney and you represent an economic threat to the legal profession because you're depriving other attorneys of legal fees. So the only way UPL enforcement really can survive is if it's prosecuted on a selective basis against those who represent an economic threat to the legal profession. In all three examples, you provided the same type of advice, but it's only in the third one where you're a licensed attorney in another state that you represent an economic threat to the legal profession, and therefore that's the only one where you would probably be charged. Let's give some other examples of things that could constitute violation of UPL and being prosecuted for such. Your loved one is being arrested and you shout out to them, tell the officer you're exercising your right to remain silent. Your loved one has charges pending against them and has been released pending trial. You write them a letter describing a similar case where a defendant was acquitted under similar circumstances, and you enclose a copy of a published court opinion showing such. Your loved one is buying a house, and you explain how courts have interpreted certain mortgage and financing laws. You inform a loved one how to fight a parking ticket in court. Who hasn't done that? Probably everybody. The fact of the matter is the unprosecuted commission of UPL is exceeded in this nation only by parking tickets, probably themselves. The essence of UPL enforcement is upon selective enforcement. So now let's take a look at this concept of selective enforcement. We often hear prosecutors saying, the law is applied equally to everyone. Anyone who breaks the law has to account for it. Well, that's a bunch of bunk. Because the fact of the matter is the U.S. Supreme Court, numerous appellate opinions, have come down countless times indicating that prosecutors have a huge amount of prosecutorial discretion. They can charge who they want, and they can decline to charge whoever they don't want to charge. So now let's look at UPL and what are the characteristics of this selective enforcement gig. You have people without legal knowledge, without a knowledge of the law, who charge services for free. You have people without a knowledge of the law who perform legal services as a business. You have people possessing knowledge of the law who perform knowledge for free, and people who possessing knowledge of the law who perform it as a business. So the criteria is ultimately based upon selective enforcement, and the problem is that all of our close friends, family members, and relatives fall into squarely the category where they're just trying to help out. But chances are they don't know too much about the law. They're not going to be of that much help anyway. But the people who really can help them are their friends and family members who are attorneys in another state who do have knowledge of the law. So there's a disconnect here because the people who can really help them are precluded from helping them and will be selectively prosecuted. The people who can't help them at all, the state bar doesn't care about. Your family member, your brother or sister, they'll let you say whatever you want because they know you really can't help them. So there's a disconnect between the actuality of who can help and those who are being prosecuted for representing an economic threat to the legal profession. So the primary propaganda argument of a state bar to prosecute UPL, the unauthorized practice of law, is that non-attorneys perform legal services that are incompetent. If you don't know the law, they're saying you're incompetent. The problem is if you're not licensed in the state, but you're licensed in another state, you may actually have a lot of competency in the law. But let's look at the issue of, even within a state, basically, the concept of non-competent, of people who are non-competent with respect to the law, providing legal services. Here's an interesting thought to ponder. In virtually every single instance where a licensed attorney, in virtually every single instance in a state where a licensed attorney who is allowed to engage in the practice of law files any type of legal motion in a court which is opposed by another licensed attorney, one of them wins and one of them loses. And that means that basically one of the attorneys were wrong and one was right. So presumably, since the losing party was legally wrong, since two licensed attorneys presenting diametrically opposed legal positions cannot both be right, it's inescapable that one of them has performed an incompetent legal service because they provided wrong legal advice. Their motion was denied, or if they were opposing it, that way around also. So it's very difficult. It's a very dicey issue, this concept of unauthorized practice of law, when it should be prosecuted, when it shouldn't be prosecuted, when a licensed attorney from another state should be able to help and when they shouldn't be able to help, and when it's all being predicated upon the economic best interests of the legal profession. So in my book, what I basically present is that the manner in which this is related to the good moral character standard for admission to the state bar, the public's interest is best served when licensed attorneys are allowed to enter into the legal profession by having a fair and objective good moral character standard. To a large extent, that justifies enforcement of the UPL unauthorized practice of law provisions. But when you have a subjective assessment of good moral character designed to exclude non-attorney applicants from obtaining a law license on the grounds that the state bar admissions committees don't like them, their attitude, the fact that they're glib, the fact that they file civil suits, then ultimately that places in jeopardy the entire legal monopoly, and it places in jeopardy the entire enforcement of the UPL unauthorized practice of law prosecutorial schema, because in and of itself it's based upon selective enforcement, which stands on very shaky ground based upon the economic interests of the legal profession itself. Hope you found today's presentation interesting, and we'll have the next one in a day, 2, 3, 4, 5, whatever. And remember, love right, don't fight. Bye.